Good morning, Mr. Langholz. Have a seat, and you can share your remarks as you're ready.
Thank you, Chair Valentine, members of the Commission. I'm grateful to be here to have the chance to visit with you. And I'm also grateful for your service these last several weeks in the application process. With 16 strong applicants, I don't envy your task in this busy summer of fitting in time to meet with many of us and consider our materials and now gather to select 5 nominees based on our qualifications. But we're all fortunate to have your commitment and dedication to that cause. I'd like to visit this morning just a little bit about the approach that I would take as a Court of Appeals judge if I'm fortunate enough to receive your nomination and the governor's appointment. And it really boils down to 3 main principles. I'd be fair and impartial, I'd be steadfastly committed to the rule of law, and I'd never forget that I'm deciding cases involving real people who deserve a fair process where they're respected and heard. Now, you don't need to take my word that this is how I would approach being a Court of Appeals judge. If you want to know what sort of judge I would be, you need only look at what sort of judge I was when I served as the Chief Administrative Law Judge. For 4 years, leading Iowa's administrative judiciary, I worked to build a culture based around these principles, and I practiced them myself as I decided a wide variety of disputes between Iowans and their government. So, first and foremost, I was and would be fair and impartial. Now, I've been blessed to have a wide variety of legal roles over the years. I've been a prosecutor and in the indigent defense community. I've sued the state for clients that were harmed by its actions, and I've defended the state and its employees and officers. But the role of an advocate has never come naturally to me. I've met many awesome advocates who relish that battle and fight for their clients, who want to push the law one way or the other. And don't mistake me, we need those people in order for our judicial system to work. But that's not me. The role of all of the many ones that I've had that has been the best fit was as a fair and impartial administrative law judge. It comes natural to me to try to reach the objectively correct legal result, to keep an open mind, curious to learn the facts of a case and understand the parties' arguments, and then to decide the case neutrally based on that law. And I understand, because I've made that transition before, that when you take the judicial oath, you serve the law, not your former clients, not any other former affiliations or political interests. That's also why I'm steadfastly committed to the rule of law. Again, as an administrative law judge, I heard a lot of compelling stories from Iowans, people who needed their food assistance benefits or wanted to keep their driver's license from being revoked, wanted to stay off the child abuse registry. But I had to remember that it was my duty to follow the law and to reach the result regardless of whether I liked the outcome or not. And I would do the same thing on the Court of Appeals. I would faithfully interpret our statutes, apply Iowa Supreme Court precedent, and reach the result that's required by the law, regardless of whether it makes me or you or anyone else happy. And third and finally, regardless of sort of the outside objective significance of the case, I would understand that this is the most important case for those parties, and that they deserve a fair process to be heard and respected. This, research tells us that the process is just as important than the result in a case, that parties are more likely to abide by the rulings, to not commit crimes again, if they believe that the process was fair. And in fact, it affects everyone who's observing the process. And so this was a touchstone of how I worked as an administrative law judge. It affected how I presided over cases, how I wrote my decisions, and I talked about some of that in my application. And it's the same it's the same way I would approach things on the Court of Appeals as well. I would dive in to the briefs and the record to really understand how things, the case that is before me that the parties are presenting. I'd approach oral argument with that same humble and respectful purpose, respecting the parties, the district court, my colleagues on the bench. And then I would write clear and concise decisions that help the parties understand what's happening, especially the losing party, why they're losing, and ensuring that everyone has felt heard through that process. Now, these aren't that innovative ideas of principles to follow. They're really all embodied in the judicial oath. But having lived them as an administrative law judge, they're more than just words to me. So I humbly ask for your nomination to the Court of Appeals. You have my word that I would strive every day to fulfill your trust, to live up to the judicial oath, and to make all Iowans proud of their judiciary. I really appreciate your consideration, and I'm looking forward to your questions.
And we'll start with Commissioner Graber.
Okay, thank you for your application. I don't normally go negative on asking a question, so I want to see how this kind of works this morning. I usually talk about any strengths, but in your opinion, what would be a weakness that this commission, in your opinion, would really want to avoid in choosing the next judge on the Court of Appeals?
I think one of the most important qualities of a judge is humility, and that drives approach to cases, how you think about the law, how you interact throughout the case with the parties. We've heard some discussion today, and as I've visited with Court of Appeals judges about the importance of collegiality on the court, and being humble and understanding that as any one judge, you're not the most important person in the room. You're not even the most important judicial officer in the room. I believe that's the trial court judge who was there and originally administering justice. But you need to be humble and open-minded. So I think the most significant mistake would be bringing someone that doesn't have that quality.
Commissioner Chase.
Thank you. Thank you for your application. As an attorney in private practice, please share in more detail your trial experience, jury or bench trials, and the types of people or entities that you have represented.
Yeah, so I had a pretty wide-ranging trial experience. I've had 2 jury trials. One was criminal as a prosecutor. One was a civil case, an employment discrimination case where I represented a retired department official through a week-long jury trial, successfully obtained a defense verdict. I lost the criminal case, and then defended that verdict on appeal as well, in a pretty interesting challenge to a jury selection issue that arose in the case. In addition to those jury trials, I've had a number of bench trial experiences, ranging from representing a small business owner in a small claims case to larger clients that were suing the state with open records related issues and disputes over tax credits. As in the Attorney General's office, I've also done a range in both state and federal court related to challenges to statutes, so a number of preliminary injunction proceedings, summary judgment, motion to dismiss, those sorts of things. So I've represented individuals, businesses, the state in a wide range of areas.
Thank you.
Commissioner Pearson.
Thank you for your application. You have had the opportunity to work for 2 different attorney generals. How has that, or what things that have occurred during serving with each of those individuals has kind of shaped you or would prepare you better to serve on the Court of Appeals?
Well, I have. It's been an honor to work for both Attorney General Tom Miller and Attorney General Brenna Byrd. It's a privilege to be able to stand up in court and represent the state. And I've had some amazing experiences. I don't think there's any other role in 2 years where I could have had the opportunity to do a dozen appellate oral arguments, over, at the Iowa Supreme Court and the Eighth Circuit and in the Court of Appeals, and had, a jury trial and, defend, be involved in a whole wide range of very interesting cases. It's really strengthened, again, my appreciation for the rule of law, defending cases, and giving the state a defense, regardless of whether it's a challenge that's coming sort of from the political left or the political right, on many of sort of the public interest litigation that we're involved in, and understanding that, the court system needs to work that process out fairly. It's also reinforced for me, how much I love really engaging with the law, with research and writing, in the way that one does on the Court of Appeals, and strengthened my commitment that this would be a good step for the next public service.
Thank you.
Commissioner Marquardt?
In your opening statement, you focused on your time as an ALJ. And it's my understanding that you were really making decisions as an ALJ for about 10 months, I believe.
About a year, I think,
Yeah.
yes.
Why'd you focus on that point when you've had quite a wide variety of experiences elsewhere in your career?
Well, like I said, I really feel like of all of the experiences that I've had, that job is the one that has best fit my talents, best fit my temperament, and I think is also the best example of what sort of Court of Appeals judge I would be. So I think it's the most relevant experience that I have for this job. It's a job that I loved. It was an honor to be able to do, and it's the one that helps me be most confident that I could step right up to the role of a Court of Appeals judge and help serve Iowans in that role.
Commissioner Henderson?
No questions, thank you.
Commissioner Parrish?
One of the beauties of our system is that we have 3 separate branches of government. And I think when you think about a person, say, coming out of the executive branch, what background or experience or about yourself can you tell us that those 3 branches are sacrosanct or sacred to you, coming out of the executive branch with the issues that we have developing in our court systems today?
Yeah, and I've had the opportunity to work in all 3 branches of the federal government. Most of my experience in state government has been in the executive, but I've been in roles where I've worked closely with the legislature and with the judiciary, and oftentimes feel like I'm kind of right there at the center of understanding the separation of powers. My experience being there, has given me an appreciation for the importance of each of those branches. How important it is for each of them to do their job well, for the other branches not to overstep into that area. And I think as it relates to sort of being a Court of Appeals judge, that experience and understanding of seeing how the legislative process works from the inside, or at least kind of from the quasi-inside of the executive branch, and understanding the rulemaking process, helping advise agencies and officials as they try to understand what the judicial branch might do with a particular issue if it ends up in litigation. I think those are all things that would be add value to being a Court of Appeals judge.
Thank you.
Commissioner Hoyt?
No questions, thank you.
Commissioner Hoytink?
Talk to me a little bit about your experience with Judge Steve Colleton as a judicial clerk. How did that inform your desire to be a judge? What did you learn from that experience, and maybe what would you take with you from that experience?
It was an incredible experience. I think almost any judicial law clerk will say it's one of the most formative experiences of their legal career. It certainly was for me. Judge Colleton was a brilliant jurist, is hardworking. He was committed to making sure that he took the proper role of an intermediate appellate judge, just like the Court of Appeals. He understood that the Eighth Circuit was not the Supreme Court, that it's important to faithfully follow Supreme Court precedent. And those are all qualities that I would seek to emulate, to follow the law, to be hardworking, to dive in deeply to understand the record in the case and the history of the law. Now, I recognize one of the differences between the Eighth Circuit and the Court of Appeals is that there's a much higher volume of work on the Iowa Court of Appeals, and that I would also, Eighth Circuit judges have 3 or 4 law clerks and a judicial assistant, and although the Court of Appeals, generously has a law clerk and part of a staff attorney, it's not quite the same level of resources to be able to dive in quite as much. So much of the lessons that I learned, from the Eighth Circuit would be things that I apply, but I also recognize that we'd have to adapt to the circumstances of the Iowa judiciary.
Commissioner Schnur.
Real quick, thank you for your application, Mr. Langholz. I want to just build a little bit on Mr. Parrish's question and ask a little bit about the confidence the public has in the judiciary. It seems to be shaken recently, if we read that. And one of the issues that has been touched on by other commissioners is independence of the judiciary. Can you address the importance of independence of the judiciary and the confidence the public can have in the judiciary?
Yeah, I think the independence of the judiciary is absolutely critical. I think the public, this process is a good one for anyone to be able to be watching right now and understanding, those of us that are seeking to serve on the Court of Appeals, what our motivations are for doing that, and to have the opportunity for you all to ask us questions and see that. I think, I understand that when you take a judicial oath, that's a serious thing, that you're moving into a new role, that, what you've done in the past, is not part of how you, approach judging. I mean, that's part of why judges wear black robes. Their individual identities, their past identities, are supposed to be, shaken from their approach. The judicial oath, Chair Valentine, as you talked about, in your opening remarks, says that judges are to decide cases without fear, favor, affection, or hope of reward, and that's a serious thing. And I'm proud of our Iowa judiciary. I think our judges approach things that way and would want to continue to help make all Iowans proud.
Thank you.
Commissioner Roberts.
We've been talking today with candidates about their capacity for empathy. So kind of curious if you would be able to share maybe just some experiences that you've had, whether in the AG's office or as an ALJ, public defender's office, or even private practice, about maybe how you've been with the client on a difficult day, or a party has appeared before you as an ALJ on a really difficult day, and if you have any illustrations to share in that regard.
Yeah, I mean, so I've had that experience, in many of those ways that you just suggested, with respect to, kind of the client situation. I mean, going through a jury trial with a client that, is accused of, engaging in discrimination, is a significant experience for them. That was, going through that and understanding and being there before and after and during a case, and helping walk through so that they understood what was happening and why we were doing things that we were doing, I think is important. I think of those experiences, the one that, best, where I grew to have the greatest appreciation for that empathy was as an administrative law judge, because most of those cases were cases where the parties appearing before me didn't have lawyers assisting them. And so a key part of what an ALJ was doing was helping to explain explain the process, get people comfortable with that. You know, an ALJ, which is one difference, you know, between an administrative law judge and, you know, an appellate judge, you know, has a duty to help develop the record too. So I would be asking questions, you know, sometimes more, you know, when a client really, or when a party rather really needed that. You know, I've had the experience of, you know, conducting in-person child abuse hearings where, you know, the person accused, you know, breaks down in tears on the stand and trying to help through that process, and then making sure that as I was writing a decision in that case, that even if I was ruling against them, that I was being respectful and understanding of, you know, the case that they were making, and if I had to conclude that I didn't believe something that they were saying, I explained clearly, you know, why that was. You know, I talked in my application as well, and so I won't belabor it about, you know, one of the most, you know, sort of consequential cases, you know, with this, where a woman that was seeking to be able to be a foster parent, and, you know, by asking some additional questions, was able to, you know, really understand why she was there, and tailored my decision, again, still denying her her request, but I think helping to make that a much better experience for her. And I take that same approach on the Court of Appeals.
Thank you. Our time is up. We appreciate your application, and we wish you all the best.
Thank you.
Thank you.